If you live anywhere near a district line that was drawn to give a minority community a fighting chance at electing someone who looks like them, you need to hear what just happened at the Supreme Court, because the rule that protected that line for the last 4 decades just changed under your feet. On April 29, 2026, the Supreme Court handed down its decision in Louisiana versus Callais, a case that started as a fight over 8 congressional seats in one state and ended as a fundamental rewrite of how Section 2 of the Voting Rights Act actually works. 6 justices in the majority, 3 in dissent. Justice Samuel Alito wrote the opinion that will be cited in redistricting fights in every state in this country for years to come. Justice Clarence Thomas wrote separately to say the majority did not go far enough. Justice Elena Kagan wrote for herself, Justice Sonia Sotomayor, and Justice Ketanji Brown Jackson, and she used a phrase that is now being quoted everywhere, that Section 2 has been rendered, in her words, all but a dead letter. I am going to walk you through exactly what this case was about, what both sides argued, what the court actually decided, and why legal scholars on both the left and the right are telling you this changes the map, literally, for the rest of this decade. Stay with me because the second half of this breakdown is where it gets personal for anyone who has ever wondered why their district looks the way it does. Before we go further, if this is the kind of legal breakdown you actually want, the kind that gives you both sides instead of a headline built to make you angry, subscribe right now and turn on notifications. I track Supreme Court decisions the moment the opinions drop, not 3 days later after cable news has already flattened it into a talking point. This channel exists so you understand the actual holding, not just the reaction to it. Let's get into the facts. To understand why this case matters, you have to go back to 1965 in a single sentence that reshaped American democracy. Section 2 of the Voting Rights Act says that no voting practice or procedure can be imposed in a way that results in the denial or abridgment of the right to vote on account of race or color. For decades, courts read that sentence to mean states sometimes have an obligation to draw districts where minority voters, who often vote as a cohesive bloc, have a realistic chance to elect a candidate of their choice, even if that means race has to be a factor in how the lines get drawn. That framework came from a 1986 case called Thornburg versus Gingles, and it has been the backbone of minority representation litigation in this country for 40 years. But there has always been a tension sitting underneath that framework, and it is the same tension at the heart of the 14th Amendment's Equal Protection Clause. If the government is not supposed to sort citizens by race, how can a court order a state to draw a district specifically because of race? That contradiction sat mostly unresolved for decades, moving in and out of the spotlight depending on which case reached the court. Louisiana versus Callais is the case that finally forced the question all the way to a decision, and the state at the center of it did not choose this fight. It was forced into it from 2 directions at once. Here is a worked example that makes the abstract problem concrete. Imagine a state with 6 congressional districts and a black population large enough, roughly a third of the total, that a fairly drawn map would reasonably produce 2 districts where black voters could realistically elect their preferred candidate. Now imagine the map on the books only produces 1 because the lines were drawn to spread black voters thin across 5 different districts instead of concentrating them into 2. Under a straightforward Section 2 analysis, that is the exact fact pattern that triggers a lawsuit, because the map is producing a result, not necessarily an intent, but a measurable result, where a racial group's votes carry less weight than the state's demographics would otherwise suggest. That is precisely the situation Louisiana found itself defending after the 2020 census, and it is why the first lawsuit against the state's map succeeded before this case ever reached the Supreme Court. It is also worth knowing that this is not the first time the court has trimmed the Voting Rights Act. In 2013, in a case called Shelby County versus Holder, the court struck down the formula behind Section 5, the part of the law that required certain states with histories of discrimination to get federal approval before changing their voting rules at all. After that decision, Section 2, the section at issue in Callais, became the single most important remaining tool for challenging discriminatory maps after the fact, rather than before the fact. That history matters here because it means this decision is not happening in isolation. It is the second major narrowing of the same statute in just over a decade, and civil rights attorneys who lived through Shelby County are watching this decision with that history very much in mind. The first segment of this story starts with a separate lawsuit called Robinson versus Ardoin. After the 2020 census, Louisiana redrew its congressional map with only one majority black district out of 6, even though black residents make up roughly a third of the state's population. A group of black voters sued, arguing that map violated Section 2 because it diluted their voting power. A federal judge in that case agreed and ordered Louisiana to draw a second majority black district. Under real pressure and a real court order, the Louisiana legislature passed a new map known as SB 8, which created that second majority black district, this one running through Baton Rouge and up along the Mississippi River, and in doing so, the state protected several of its most powerful Republican incumbents, including the Speaker of the House and the House Majority Leader, by concentrating them into safer districts elsewhere. That map satisfied the Robinson plaintiffs. It solved one lawsuit. But it created another one immediately because a separate group of voters who identified as non-African American, led by a plaintiff named Philip Callais, turned around and sued the state, arguing that SB 8 was itself unconstitutional because Louisiana had used race as the predominant factor in drawing that second district, which is exactly the kind of racial sorting the Equal Protection Clause is supposed to prohibit. So Louisiana found itself trapped between two lawsuits pulling in opposite directions, one saying the state had to consider race to satisfy the Voting Rights Act, the other saying that considering race that way violated the Constitution. If you want to understand why this case landed at the Supreme Court, that is the entire reason. It was not a hypothetical law professor's puzzle. It was a state genuinely caught between two federal court orders that could not both be satisfied at the same time. The second segment is the argument that the Callais challengers actually made, and it deserves to be laid out clearly because it is more than just, "this is unfair." Their argument rested on the Equal Protection Clause, and specifically on a line of cases going back to Shaw versus Reno in 1993, where the court established that when race becomes the predominant factor in how a district is drawn, that map has to survive strict scrutiny, the highest and hardest standard in constitutional law. To survive strict scrutiny, the government has to show the race-based action serves a compelling interest and is narrowly tailored to achieve it. The Callais plaintiffs argued that Louisiana's second-majority black district was not narrowly tailored to anything. They pointed to the district's shape, stretching nearly 250 miles across the state to connect scattered black population centers, and argued that shape was the fingerprint of race predominating over every other traditional redistricting principle. Things like compactness, keeping communities of interest together, respecting existing political boundaries. Their position was straightforward. Complying with a federal statute does not automatically count as a compelling interest strong enough to justify sorting voters by race, especially when the state itself, through its own admission in court filings, acknowledged it drew the map to satisfy the Robinson order while also protecting specific incumbents by name. If you are trying to understand the challenger's argument in one sentence, it is this: the Constitution does not bend to a statute, and a state cannot use compliance with the Voting Rights Act as a blank check to draw districts explicitly by race. The third segment is what the state of Louisiana and the Robinson interveners argued in response, and this side of the argument matters just as much. Their position was that Section 2 has always required race-conscious remedies in certain circumstances, because the entire point of the statute is to correct situations where race-based voting patterns, not race in the abstract, but the actual documented reality that white and black voters in a given region tend to vote differently, and white bloc voting has historically prevented black candidates from winning, would otherwise shut a community out of representation entirely. They argued the Gingles framework built in 1986 was never a wild card. It was a structured three-part test requiring plaintiffs to prove a minority group is large enough and compact enough to form a majority in a reasonably drawn district, that the group is politically cohesive, and that the majority votes as a bloc sufficient to usually defeat the minority's preferred candidate. Louisiana and the Robinson side argued that when all three of those conditions are actually proven with real data, not just alleged, taking race into account to fix the problem is not a constitutional violation. It is the remedy the statute requires. And courts have upheld that structure for 4 decades because Congress explicitly amended the Voting Rights Act in 1982 to make clear that a discriminatory result, not just discriminatory intent, is enough to trigger Section 2 liability. Their broader argument was that if the court used this case to gut that framework, it would not just affect Louisiana, It would functionally rewrite the tool that has been used to elect the vast majority of Black and Latino members of Congress from the South over the last several decades, and it would do so without Congress ever voting to change the statute itself. The fourth segment, before we get to what the court actually decided, is the chain of earlier cases that set up this exact showdown, because the majority opinion did not invent its reasoning out of nowhere. It built on a line of precedent stretching back 30 years. In 1993, Shaw v. Reno established that a district drawn so oddly shaped, it could only be explained by race triggers' strict scrutiny, even if the state's motive was benign or remedial. In 1995, Miller v. Georgia extended that principle, holding that race does not have to be the only factor in a district's design, only the predominant one, for strict scrutiny to apply. In 2017, Cooper v. Harris reaffirmed that even when a state claims it was complying with the Voting Rights Act, courts still have to independently verify that the state actually needed to use race the way it did, rather than simply taking the state's word for it. And in 2022, in a case called Wisconsin Legislature v. Wisconsin Elections Commission, the court sent a similar dispute back down, specifically because the lower court had not conducted a full strict scrutiny analysis before assuming VRA compliance was automatically a compelling interest. Each of these cases chipped away, one ruling at a time, at the assumption that satisfying Section 2 automatically excuses a state from equal protection scrutiny. Louisiana v. Callais is the case where that chipping finally became a full break. If you trace the citations in Justice Alito's opinion, nearly every one of them is a stepping stone from this exact line of cases, which is why legal scholars who have followed this area closely describe this decision less as a surprise and more as the last domino in a sequence that has been falling since 1993. The sixth segment is what Justice Alito's majority opinion actually held, and it lands closer to the Callais challengers, though not in the sweeping way some commentators are describing it. The court did not strike down Section 2 as unconstitutional on its face. What the majority held is narrower, but still consequential. The opinion states that Section 2 liability requires evidence supporting a strong inference that the state intentionally drew its districts to give minority voters less opportunity because of their race, and the court found that Louisiana's stated interest in complying with the earlier Robinson Order, without more, was not automatically a compelling interest sufficient to survive strict scrutiny once race predominated the map's design. The majority went further and significantly reworked the analysis that lower courts have used under Gingles for 40 years, raising the bar for what plaintiffs have to show before a court can order a state to draw a race-conscious remedial district in the first place. Justice Thomas's concurrence, joined by Justice Gorsuch, argued the majority should have gone further still and held that race-conscious redistricting to satisfy Section 2 is never permissible under the Constitution, full stop, calling the entire framework built since the 1980s an unconstitutional racial entitlement dressed up as a remedy. The majority opinion did not adopt that full position, which is itself worth noting, because it means the six-justice majority left daylight between itself and the two-justice concurrence, and that daylight is exactly where the next round of litigation is going to live. The seventh segment is Justice Kagan's dissent, and it deserves to be presented on its own terms because it is the sharpest and most quoted part of this entire decision. Kagan argued the majority effectively demanded an impossible standard, that states now have to prove race predominated in a discriminatory sense, while simultaneously being told that fixing documented racial vote dilution under a federal court order does not count as a strong enough justification for using race at all. She wrote that this reasoning traps states exactly the way Louisiana was trapped, unable to comply with one federal mandate without violating another, except now with the escape hatch closed only on one side. Her dissent argued this decision effectively guts the primary remaining tool that voters of color have had since 1965 to challenge maps that dilute their political power, and she specifically wrote that the ruling renders Section 2 all but a dead letter in much of the country going forward. Justice Sotomayor and Justice Jackson joined her in full. It is worth being honest about what the dissent does and does not say. It does not argue that the majority ignored the text of the Constitution. It argues the majority misapplied decades of precedent in a way that will have a real-world effect, regardless of how narrowly the opinion is technically written, and that the practical result whatever the legal label, is fewer majority-minority districts across the South and the Southwest over the next decade. The eighth segment is what happens now, procedurally and practically, because a Supreme Court opinion does not redraw a single line by itself. Louisiana's SB 8 map was sent back down with instructions that it cannot stand as currently drawn, which means the state legislature or a lower court now has to produce a replacement map that satisfies this new, harder standard. States with similar litigation already pending, and there are several, are watching this opinion get cited within days, not months. Legal analysts tracking the case have already pointed to a ripple effect reaching Alabama, where a separate congressional map fight over a second black opportunity district was working through the courts on a nearly identical Section 2 theory, and in the weeks after Callais came down, the Supreme Court itself allowed Alabama to use a map that a lower court had previously struck down as racially discriminatory, a decision that would have been much harder to justify before Callais reset the baseline. That is not speculation about what might happen someday. That is an actual documented sequence of events that followed within weeks of the opinion, and it tells you the ripple effect is not theoretical. Expect the same fight to surface in Georgia, in Texas, and in South Carolina, all states with active or recent Section 2 litigation over congressional or state legislative maps drawn after the 2020 census. Civil rights organizations, including the NAACP Legal Defense Fund and MALDEF, issued statements calling the decision a direct threat to representation for voters of color, with one MALDEF official stating publicly that the decision invites states to dilute minority voting strength. On the other side, organizations that have long argued Section 2 pushed race-conscious redistricting further than the Constitution allows called the decision a long overdue correction, framing it as finally holding the Voting Rights Act to the same colorblind standard the Equal Protection Clause demands everywhere else. Both of those reactions are strategic positioning as much as legal analysis, and you should treat both with a healthy amount of skepticism, because the actual scope of the opinion is going to be fought over in lower courts for years before anyone can say with certainty how far it reaches. The ninth segment is what this actually means for you if you live in a state where race-conscious districts have shaped who represents you in Congress or in your state legislature. It means the standard your state now has to meet before drawing or being ordered to draw a district with race as a predominant factor just got significantly harder to satisfy. If you live in a state currently facing Section 2 litigation, whether that is a state trying to defend an existing minority opportunity district or a state being sued to create one, this opinion is now the first thing every attorney on both sides cites in every filing. If you want to actually understand how this affects your own district, the concrete step is to find your state's redistricting commission or Secretary of State's website and search for any pending Section 2 or racial gerrymandering litigation involving your congressional or state legislative map. Most states publish active litigation dockets publicly, usually under a redistricting or elections legal affairs section. If nothing is pending in your state right now, this still matters for the next redistricting cycle after the 2030 census, because the standard state legislatures will be told to follow when they draw new lines has now shifted, and shifted in a specific, citable, and permanent way. If you want to go one step further, look up who represents you in your state legislature's redistricting or elections committee, because those are the people who will be directly responsible for applying this new standard the next time your state's maps come up for revision, whether that happens because of a new census, a court order, or a voluntary redraw. Knowing their name now, before the next fight starts, puts you ahead of almost everyone else watching this unfold only when the next lawsuit makes headlines. Let's step back and name the single thread running through everything we just covered. This was never simply a case about 8 congressional seats in Louisiana. It was the collision of 2 constitutional commitments that have coexisted uneasily since 1965, the promise that government will not sort citizens by race, and the promise that a discriminatory voting system will not be allowed to shut a community out of representation. The Supreme Court did not resolve that tension by declaring one side entirely wrong. It moved the line significantly in one direction, while leaving real questions unanswered about exactly how far lower courts are supposed to carry this new standard into the next case, and the next state, and the next map. Justice Thomas wants the line to move further. Justice Kagan wants it back where it was. The 6-justice majority landed somewhere in between, And that in-between space is where the next decade of voting rights litigation in this country is going to be fought, district by district, state by state, case by case. It is also worth sitting with why both sides genuinely believe they are protecting democracy, because that is not just spin from either camp. The challengers and the majority that sided with them believe a government that sorts its citizens by race, even for a remedial purpose, is drifting away from the colorblind constitutional promise the country has been trying to build since Reconstruction, and that a statute passed in 1965 should not be read to require race-based line drawing forever without an endpoint in sight. The dissent and the civil rights organizations standing behind it believe that pretending race no longer shapes how people vote, or how maps get drawn, or who wins elections in large parts of this country, is its own kind of fiction, and that removing the primary legal tool used to catch and correct racial vote dilution leaves communities with no real remedy at all when it happens. Both of those are serious, good faith positions rooted in different readings of what the Constitution and the Voting Rights Act are actually supposed to accomplish together. And pretending only one side has a legitimate argument does a disservice to how genuinely difficult this area of law has always been. If there is one thing worth carrying away from this breakdown, it is that understanding a Supreme Court decision on its own terms, both sides, both arguments, both the majority's reasoning and the dissent's warning is the only way to actually know what changed and what did not. You deserve better than a headline built to make you furious or a headline built to make you relieved. You deserve the actual opinion, explained plainly, so that when your own state's map gets challenged or redrawn or defended in court, you already understand the framework the lawyers on both sides are going to be arguing over. That is what this channel is built to give you. Every single time a decision like this comes down. If this breakdown helped you actually understand Callais instead of just reacting to it, share it with someone who has been trying to make sense of the headlines, subscribe for the moment the next major ruling drops, and I will see you in the next one.